Hello, my name is Vincent Cassiano, and I'm an elder law and estate planning attorney in San Diego. Rest assured you've reached the right attorney, as I've been practicing in the area of estates and trusts for over 20 years, and I've drafted literally thousands of estate plans, from the simplest to some very complicated plans for multi-million-dollar estates. What I'd like to talk about today is, how do you deal with a beneficiary that's disappointed because you didn't leave them as much as they thought they should receive? The first thing I tell most people is, do not procrastinate in getting an estate plan in place. Most frequent attacks on the validity of an estate plan are based on capacity and undue influence. With respect to undue influence, you have to understand that people are more easily unduly influenced the older they get, as the more likely it is that they will begin to experience some sort of cognitive decline. And believe it or not, more than 70 people die without having an estate plan in place. Why? Because they procrastinate and never get around to it. The next, which is probably just as important, if you're going to do a plan, don't do it yourself. Retain an experienced elder law and estate planning attorney to help you design and draft your documents. Whatever you do, don't try to do it yourself, because more than likely, you're not going to do it right. The value of utilizing an experienced attorney is that they'll be able to advise you on the best way to achieve your objectives. If you try to do it yourself, you don't even know if what you've designed is going to be legal or whether it will stand up in court. Every year, thousands of do-it-yourself estate plans, including wills and trusts, are challenged because of inconsistencies, ambiguities, missing language, or they don't just sign them the right way at the end. These are people that are trying to save a little bit of money by using LegalZoom or Rocket Lawyer or something like that. The value that I offer my clients is that I work with them every step of the way to make sure we get it right. The next thing I think is very important is, you have to avoid the appearance of undue influence. It is really common for me to be contacted by adult children who are trying to make sure that their parents' plans are in place and that they're up to date. And the parents have even said to the children, hey, call an attorney. Can you set this up for me? What I have to explain right away is, hold it, let's take a step back here. I want to make sure that whatever the parents want, the person that I'm working with, whoever my client is, that those objectives are going to be followed. And the easiest way for that to be challenged is on undue influence, right? Undue influence means that a beneficiary has pressured or persuaded their parent to the extent that their independent decision-making has been overpowered. So it's not really their decisions. As a result, if you left a gift to a beneficiary and it's determined that they unduly influenced you, well, that gift is going to go away, right? If your estate plan favors somebody that you allowed to be at those meetings and take part in the consultations with the attorney, that is the simplest way to have that plan thrown out. Understand that I have a unique perspective on this, because not only do I draft plans, but I litigate them as well. So one of the first questions I'll ask the drafting attorney in a deposition is, who did you speak to? Who was at the meetings? And if that child that was favored was there and the child that was not favored was not, that's pretty easy for a judge to come up with the fact that that parent was probably unduly influenced. So you want to avoid that. One of the other things you might want to consider, this isn't always right, is disclosing the contents of your plan to your family. So if you have somebody that you're leaving less to, you may want to let them know. I think this is a little different than if you're totally disinheriting a child because that child is a problem child and they've just caused you problems in the past. But if it's a child that you're leaving a little less to, or maybe a lot less to, because maybe they've done very well, or you believe that another child really needs more, you might want to disclose that to the entire family so everybody's aware of your wishes. That way, they're not finding out after you've passed and then want to fight the plan. Okay. Next, and this goes along with not procrastinating, as I said before, is you may want to consider, if you believe that people are thinking about contesting your plan because of your mental capacity, you might want to consider getting an opinion of a licensed psychiatrist or psychologist, because your estate plan can be invalidated if you lack the requisite capacity to appreciate its consequences. And there's thousands and thousands of cases on this, and this gets into expert witnesses and so on and so forth. But the bottom line is, if at the time that you drafted your plan, you had an opinion from an experienced psychologist or psychiatrist, then it's going to be a lot harder for that beneficiary to claim that you lack the mental capacity if there was a determination that you had the capacity. And also, sometimes you might want to get an opinion as to whether or not you've been unduly influenced, or whether or not the factors concerning undue influence are there. And I have done that with many clients where we believe that a contest was more than likely to occur. And in that regard, you do want to include a no contest clause in your plan. But beware that in California, as a result of a change in law over 5 years ago now, no contest clauses do not have the same bite that they had before. It used to be that if you could put a clause in your will or trust that said that if anybody contests this and if they don't win, that's it, they're cut out just for contesting it. Well, now that's different. With a lot of contests, if you can show just probable cause to bring that contest, even if you ultimately lose on claiming that the will was invalid or the trust was as a result of undue influence, if there was probable cause for you to bring that, then you're not going to be cut out. One of the other strategies I use where we think it's more than likely that somebody's going to contest it is to restate the plan every year. And that's because if you restate your plan every year and you say basically the same thing, you're validating what you said in the past, that beneficiary doesn't have to just get one plan thrown out. They have to get each one of those plans thrown out. So if you did it 4 times, they have to get each one of those 4 plans thrown out based on some grounds. And if the grounds are incapacity, then they have to show at each time, each year, whenever it was signed, that you lack the capacity at the time you signed it. So that would make it a heck of a lot more expensive and a heck of a lot harder to do. Lastly, and this does happen a lot, is you want to make sure you're keeping your original documents in a safe place. You want to store it in a location. You want people to know that you trust where it is so that you have those original documents available. In addition, I do recommend that you use some form of online storage in an encrypted vault so that you've got copies of those documents so people know where they are. Because you sometimes can have documents that are not originals hold up in court, but you want to be able to show some sort of chain of command of what happened to them and are these really the originals. So the bottom line here is you want to make sure that you retain the services of an experienced elder law and estate planning attorney that has experience in not only drafting these plans, but litigating them as well, so they can best advise you on how to design a plan that will minimize the likelihood of somebody who does contest it ever succeeding. Please give me a call or text me at 619-800-6820, as I'm more than happy to talk to you about how I can help.